Hi guys, welcome back to Nairobi Legal. In case you're interested in any legal documentation, I've created a section for drafting, and each and every day I'm going to be posting at least one different contract so that you learn how a contract appears and what elements does it need to have for it to be a valid contract or agreement. For this particular video, I want us to review a partnership agreement, and by the end you must be in a position to actually make your own partnership agreement, or rather draft your own partnership agreement without any problem. And so the example you see on your screen is a partnership agreement between Rogers Limited and Sese Limited, and this partnership agreement is for an exclusive media partnership for South Soul live experience. So by the end you must be in a position to draft your own partnership agreement in compliance with the elements of a valid contract. When it comes to drafting a partnership agreement, these are the key parts you need under your partnership agreement, and this is just a sample that you can read through to see how each part is supposed to be structured. So remember, the first thing is for you to at least have a date when this partnership agreement is being made. Then you're going to have the parties. In this case we have Sese Limited and Rogers Limited. And of course you have to go ahead and describe the physical address for these parties so that they can be identified. In this case these are two companies. You also need this section where this section, as you can see already, it describes the kind of work that the companies are involved in. Remember, this partnership could also be between individuals. So you need this section, the whereas section, where you're going to talk about the work that Rogers Limited is involved in, and then the work that Sese Limited, or Sese PLC is involved in. So basically this is the feel of how the document should start. Once you're done describing what the companies are involved in, you need to go ahead and create an interpretation section. Remember that the words that are used in the partnership agreement, a word can have several meanings, so it's good for you to define particular keywords that you have incorporated or rather put in your partnership agreement. After the interpretation section, the next step is for you to at least describe the obligations of the parties to the partnership. Remember, in this particular example, our two partners are Rogers Limited and Sese PLC. As you can see already, these are the obligations that Rogers is supposed to fulfill as far as the partnership is concerned. Having listed the obligations of the first party to the partnership agreement, the next step is again to list the obligations of the second party to a partnership. Of course, like I said before, this particular example, we're using Rogers Limited and Sese PLC. So these are the obligations of Rogers as far as that media partnership is concerned. After stating the obligations of both parties to a partnership agreement, the next step is for you to state the date on which the partnership agreement is to be effective and when it is supposed to end. This is also very vital. And the next component of this partnership agreement is what we call the force majeure clause. This is a frustration clause. Remember, circumstances may happen beyond the control of parties to a partnership of agreement, meaning that someone can no longer fulfill their obligations that they set out to perform when they signed the partnership agreement. An example would be if you organized an event at Congress course, and now we have a corona happening at the moment. Of course, the artist you contracted may not be able to come to Kenya and perform. In that case, there are circumstances that have come up beyond the control of parties to a partnership, and the examples are listed here. As you can see, we call most of these things acts of God. They're beyond your control. You can't actually stop them. And so this clause is very, very, very key actually. Even when it comes to employment, we'll find this frustration clause being relied on by employers to actually lay off the employees because situations are beyond their control, that an environment has occurred whereby the employee may not even be able to perform their work. Giving an example of the current coronavirus, if you employed someone as a cleaner and now suddenly you've closed down your office, of course this clause will come into play. The situations no longer allow the employee to come to work, so most likely this contract can be terminated because it has been frustrated. So this is a very fundamental clause that you need to include in your partnership agreement, as you can see the examples listed on your screen. The next thing you need to include in your partnership agreement is termination. Under this section called termination, here you need, of course, to provide room for either party to decide when they can terminate the partnership agreement. Of course, maybe you can agree that if you're going to terminate this partnership agreement, either of us can do it in writing and express the intention to terminate the agreement maybe 7 days before the termination actually takes place. So remember to incorporate the termination section. It helps a lot because sometimes again you may want to walk out of that partnership, and it is prudent for you to send that notice to that particular partner and tell them we can no longer do this, and in 7 days I'll be out of here. So this is the essence of the termination section that must be part of the partnership agreement. The next key component of a partnership agreement is a dispute resolution clause. Remember, as you enter into a partnership agreement, there's a lot of excitement. You have the future, you're thinking about the very best for your partnership, but along the way problems may arise, and so it's very good for you to anticipate these future occurrences. And you'll find that in some partnership agreements someone can include an arbitration clause, meaning that any dispute relating to this partnership agreement will be resolved through arbitration or will be resolved through mediation and not the courts. Then you can also find other parties agreeing that any dispute that will arise out of this partnership must be settled according to the laws of Kenya, meaning that you're going to refer the matter to court. Of course, as you can see in this particular example I'm using, any dispute that are going to arise in connection to the termination or existence or even validity of this partnership agreement is to be referred to the respective managing directors of Rogers Limited and Sese PLC. So this is the essence of a dispute resolution section being part of a partnership agreement. It is of essence, and you need to have it so that you know how you're going to solve any future problems that may arise when your partnership agreement goes sour. The next key component of a partnership agreement as you draft one is the no waiver of rights section. And here maybe you may state that the rights and remedies provided in our partnership agreement are not exclusive of any rights and remedies provided by law, meaning that the law could be bringing in more rights and more remedies in case one of you breaches the terms of that partnership, and you're entitled to those remedies, which could be compensation. So this is the essence of that part. The next key part is the variation section. This must be part of your partnership agreement as you draft one, and here you ensure that none of you can alter or change anything to do with that partnership agreement without the express consent or agreement of the other party. The essence of this section is to ensure that no one goes to adjust that partnership agreement in their own favor. The next again key part is the severability section, and here if a certain section of your partnership agreement is void or it's unenforceable, then in that case that section could be eliminated, but the remaining part that is not void or that is unenforceable, or rather that is enforceable, still holds, meaning that you can remove what is unenforceable and leave what is enforceable in that partnership agreement. This is the essence of this section as far as drafting a partnership agreement is concerned. You will also need to include this particular section, and the essence of this section is that you disclaim any previous conversations you might have had. Remember, prior to signing a partnership agreement, you might have been involved in negotiations, representations, anything, any discussion you might have had. So the essence of this particular section is for you to actually say that the previous conversations, agreement that we had cannot be relied upon, and what holds is this particular partnership agreement. The next thing you need also to have in your partnership agreement is a section called notices, meaning that any communication regarding the partnership agreement at hand can be communicated through maybe a letter written and sent to the postal address of the respective parties, and this is the reason why now you go ahead to provide your physical postal address where you need that letter to be delivered, as far as communication is concerned in regard to the partnership agreement. So remember to incorporate this to specify. The other thing is that you can also go ahead to say that Kenyan law shall govern the construction, validity, performance of this agreement in all respects. So what we mean here is that, of course, if you are entering into a partnership in Kenya and you want Kenyan law to apply, then you have to state that. Some partnerships can involve parties from different countries, and they would want laws of a particular country to apply to that specific partnership. This is the essence of stating that in your partnership agreement as you draft one. Now, I'm sure by now you have seen how the entire process of drafting a partnership agreement is done. And the last and most important, again, part is, remember that a partnership agreement must be executed, meaning that it must be signed, the witness in presence of the parties. So basically what I'm trying to mean here is that you write your name, your title, your signature, your date, then your witness also does the same and you sign, and this applies to both parties to the partnership agreement, meaning that if this is Rogers Limited, then we can also have a Sese PLC also having maybe its managing director signing on behalf of the company, then having a witness sign the partnership agreement. Now that becomes an entire valid partnership agreement, and without many problems, meaning that you've covered each and every corner of that particular partnership and you're sorted and you're safe. Now the essence of me creating this section is for us to understand how to draft various legal documents. And should you have any questions as far as this particular first draft was concerned, drop your comments or reach out to me and I'll be very happy to respond to you. Thank you so much. If you're new here, remember to subscribe. Asante.